Welcome everyone this afternoon to talk about drafting and preparing contracts. As a general rule, you like to be the drafter if you get the chance. Reviewing is important, not only obviously from the legal standpoint, but this is where getting the right expertise involved early is very critical, particularly on contracts that may involve unique technical requirements, specification issues, regulatory compliance, and you need to get folks outside the counsel's office.
Not long ago, I came across some boilerplate that had embedded in, paragraph 13, hyperfont 3, that the officers of the company executing the contract would thereby personally guarantee the order. That was a surprise to my CFO business client when I pointed that out to her. She didn't like it. We were able to get rid of it, but it was lurking in the ill-fated boilerplate. So I do suggest that you read it. The part of the contract that's actually, I think, the most fun to draft, but it's also the most challenging, are the operative provisions. These are the core deal terms: the who, the what, the where, the when of the parties' relationship. The only way you as the lawyer are going to be able to identify these things is to sit down or get on the phone with your business contact and be sure you understand the deal. You want to represent in the four corners of that contract what the transaction is.
Much of intellectual property law is counterintuitive. So if there are aspects of intellectual property that need to be safeguarded, make sure you do talk to someone in the counsel's office or at your outside counsel that has a very clear understanding of the intellectual property law in the jurisdictions you're going to be operating. Even though it may be a U.S. contract, if the goods are coming from or going to an overseas location, intellectual property law changes dramatically and like I say, can be very counterintuitive as to who owns what.
So when somebody says, I am the world's best manufacturer of wool blankets for your hotel chain, or I'm the world's best HR consultant, you're going to want to potentially ask your business folks, have they checked references? Do they really exist? Have they received and tested samples against the specs that you set forth in the contract? So a little bit of diligence on your part can forestall a lot of heartache for your business folks. With respect to an ongoing relationship, if I'm just saying, I'm going to buy 100 pounds of flour for Greg, and Greg's going to give me the 100 pounds of flour, I'm going to give him the check, we're done. There's really no need for there to be much in there about termination. But if I'm going to buy 100 pounds of flour from Greg from now for the next 24 months, what if the flour is crappy flour and doesn't meet my specs and I can't use it in my baked goods? Or what if he delivers late? When do I terminate?
You see here on the slide some of the results of a survey by the IACCM. Some of the notable things here are that 81% of companies can't find copies of their contracts, or they can't find signed copies and they have to ask the other side for a copy. That's always a little difficult when you're trying to rattle your saber and you don't have a copy of the signed contract and have to ask the other side for one.